Brian, okay. It's 900, and this is how you do it. Zakia, who's going to be the buyer?
Buyer.
Well,
You're choreographing that.
I'm choreographing, sure. So what you do, this is a pre-literate area, pre-literate time on the whole. People live in the same place their whole lives. Do they know who owns up to the brook, up to the big rock, up to the tree? Do they all know who owns what?
Yes.
Better rely on it. Okay, so Zakia, if you're going to sell Brownacre to Brian, everybody knows exactly what Brownacre is, right? So how are you going to do it? No writing.
We're going to have a consideration. For the consideration of those coins, we're going to, shall we shake hands?
No, you give
This is a
give a
good
piece of
question.
land.
This is a
So
good
we shake
question.
I'm not buying things.
How do you show? Well, one thing, you're showing that you're selling Brownacre to somebody else. Do you live in an area where everybody knows everybody else's business?
It's my word.
You have a witness.
Ah,
No, you give them a piece of the land.
Well, both.
Everybody's on the right track. Get all the neighbors around. Y'all are now neighbors.
is it a ceremony? Is it a formal ceremony?
You bet it is.
That
Very
we've-
formal.
We've decided upon, at some point, a formal ceremony, like
Because-
barn raising almost. But
Yeah, because this is the way you do it.
What was it called?
This is a good question. My Anglo-Saxon isn't up to it.
I think you're going to have
So
to.
what you do is you
Deliver
dig a turtle, take your,
ah,
you dig a little
it's
bit out.
so,
I gotta get my hands dirty.
No, you don't really have to,
Hey,
but
bring it
in real life you would.
They call the process itself delivery of sizing, and that's
Sizing.
giving me land.
yes, isn't it?
Symbolic.
Symbolic. But it's the
Literal
honor, but it's the
and
honor
symbolic.
system
Yeah.
too.
So does everybody saw this? Everybody's gonna know this, 20 years from now,
I can't help
40 years from now? Thank you very much.
it. You didn't buy a pig in a poke. I couldn't help it. Thank you, Sarah.
You're-
So it sounded like Brian knew what it was called.
Yeah, it's a law school topic.
Yeah, it goes back to the old
It's
days.
the old days.
Pearson v. Post and all that.
Yeah.
You see, because I went to Antioch School of Law to be a paralegal, we didn't study property law. We studied, no, for real, property law, that's what they call it. We never studied property law.
So Nadine, why don't you go sell Barnacre to somebody?
Because I don't own it.
This is a lovely answer, and I can think of a number of banks.
It wouldn't stop them for a moment.
This is, so we've come to a principle which is still just as good today as it was in 900. And this is, no one, nemo, dot, grants, what? He, she, or it does not have.
You'll know that.
You can't sell Brownacre because you don't own it, right? Okay.
This is, when we're rich, you're going to know it because Sarah's going to have T-shirts to give everybody.
I wanted T-shirts. I wanted. Nemo Dot Club don't have it on the front, and the statute of frauds on the back. I'm going to get to that. So this is when
That's the motto, the foreclosure defense league, or whatever we're gonna call it.
It's a secret password.
Be on our ties when we go to court. Where's Nemo?
So when the SJC said that it was just pronouncing the law that has been here forever. I'm putting words in its mouth, of course, but it said, the SJC in Ibanez did nothing new. It basically said, you can't grant what you don't own. It doesn't apply to mortgages. So we're going to do a little bit about the evolution of this. 1066 and all that, William the Conqueror, the Normans. And when William needed to know how much he could tax the English, because he had to pay the Danes not to attack, so he had to know how much he could get out of the English. So he sent commissioners around one summer in 1086 to figure out who owned what and how much it was worth and how much you could tax it for. So, who wants to be William the Conqueror?
I don't believe it.
Yeah, no, it's yours.
You're William the Conqueror. And you're sending your commissioners out, and they're going to go all over England.
Can't fix my crown.
And how are they going to find out what the land, what every single bit of land is worth? Every mill, every foundry, every fishing weir. How are they going to find that out? They're going to call all the neighbors. They're going to call barons and
Oh, wow.
yeah, put them on oath and have them declare. You know, this hide of land, a hide of land is enough to support a peasant family. So it's not a measurement the way we think of a measurement in feet and yards, but it's a measurement of how much it will support people. So every hide of land, every cow, every pig, and a quotation from someone who was supposedly there, no single hide, nor a yard of land, nor indeed one ox or cow, nor one pig was left out of what became the Domesday Book, the huge book of real property in England. That's why we have a pig. Pigs were valuable. A friend of mine was reading through a law report from about 1351, and he said this peasant had sold his wife for a pig worth 3 shillings. Et bene contentus est, he was well content. So a pig.
Big has a value.
Yeah. We're going to leap forward to the Great Fire of London in 1666, because that's what eventually gave rise to the Statute of Frauds. And the Great Fire was huge. It burned for 4 days. It burned something like 80% of London. Some of the great houses were spared, but ordinary people's dwellings, a lot of them were made of wood quite illegally at the time. And there was a huge problem afterwards in knowing who had owned what before the fire. So the law of evidence was not very well developed in England at that point in some respects. Calling people in as witnesses. If you were a party to a lawsuit, you could not testify in your lawsuit. So the people who knew most about a transaction couldn't testify about it. And we had a survival of that until fairly recently, in that husbands and wives couldn't testify against one another. It's a very old survival. But people were still trying to maintain that they had owned this or that piece of property by this calling in witnesses. And it wasn't working very well. Why? Because many witnesses were simply for hire. you could hire a witness to come in and testify. And I think we all know what that leads to.
Isn't that what the banks are doing now?
Yeah, we're living, yes, we're living it.
Robo-witness?
That
They call
too.
it expert witnesses.
Yep.
The 30B6 doesn't
Or super PACs.
They all have different
So
names.
it took about a decade to, I'm sorry, did I? Yeah. It took about a decade to figure out what to do, and there were several drafts of bills through Parliament. How are we going to deal not only with who owns what, but other commercial transactions, and who is liable for what? And what Parliament eventually passed 11 years after the fire was what we call the statute of frauds, but I think it's really well worth looking at the original title, which is an act for prevention of frauds and perjuries. So this act was precisely getting away from calling in live witnesses to testify about who owned what. And when Parliament passed it in 1677, where else did it become law?
Colonies.
In Massachusetts.
Massachusetts, absolutely. And it's still good law in Massachusetts. Massachusetts General Laws, Chapter 259, Section 1, and it's practically word for word from what Parliament passed in 1677. I just love this. And it provides, no action shall be brought, no lawsuit can be started, upon a contract for the sale of lands or of any interest in or concerning them, unless the contract is in writing, signed by the party to be charged, or else that party's agent. So, I think many of you have seen the older deeds, and the deed will start out, this deed witnesseth. The deed is, what's it doing? It's standing in the place of all the neighbors who knew who owned what and who sold it to whom when. So the deed is just standing in for the witnesses. And what then will the deed do? It'll give to identify the property. It'll give the metes and bounds, right? From this rock to this tree to this whatever. So what the community would have known in 900 AD, you get put down on a piece of parchment in 1677. And where Zacchaeus put the shovel in the ground and handed some to Brian, now Zacchaeus would sign it. She would sign a deed granting Brownacre to Brian. So there's a long continuity of that. And the statute of frauds is just as good today as it was when Parliament passed it in 1677. And that's what the SJC is getting at in Ibanez. That has not changed. A mortgage is an interest in land, right? So, subject to the statute of frauds, you've got to have the grantor of the grantor who's assigning the mortgage has to do it in writing, signed, now witnessed, and with a date so we know when it happened. And it's still true, no one grants what he does not have. This hasn't changed. As long as you keep your mind back on the piece of ground and what it takes to transfer it, ownership from one person to another, that's the golden thread through the foreclosure mess as I see it. Fast forward to maybe the 70s, maybe earlier than that, I don't know. and Fannie Mae and Freddie Mac and some others started, they would buy mortgages on what's called the secondary market. Somebody could be fly-by-night mortgage originator. I don't have any sign for fly-by-night mortgage originator. But as long as fly-by-night granted mortgages to somebody in the form that Fannie Mae and Freddie Mac are willing to buy, then fly-by-night could give a mortgage to somebody, and then what would the person do, the borrower do? In Massachusetts, title theory state, the borrower essentially takes a shovel full of land and gives it to fly-by-night mortgage. So fly-by-night has the legal title to the land, actually, legal title. There. And let's see, who got the mortgage from fly-by-night?
Is it Fannie Mae?
I mean, who was the borrower here?
Did we have one?
Brian was the borrower.
I thought it-
Brian owns
Purchaser?
Brown Acre.
That's right, I sold him brownies.
As borrower or as king?
Okay,
No, that's Willem over here.
so what's left here? Possession and the equitable title. Zakia, why don't you be the legal title holder? And you could pass that off to Dawn. Dawn, you're Fannie Mae. So technically, when Alan pays his mortgage off, then the legal title comes back, right? But the private banks, the big banks, Citibank, Wells Fargo, the rest of them, they had mortgage envy, I think you could say, because Fannie Mae and Freddie Mac would take bunches of people's mortgages and sell them to investors. And Fannie Mae and Freddie Mac were doing really well at it. In fact, they probably own about close to 60% of the mortgages in the country. So the big banks got a provision put in the Federal Tax Reform Act of 1986, also known as the Lawyers and Accountants Relief Act of 1986. And that enabled Citibank and Wells Fargo and the rest of them to make Fannie and Freddie look alike investment vehicles. With Fannie and Freddie, there was an implicit U.S. taxpayer guarantee that nobody was going to lose money by investing in the Fannie and Freddie investments. So the banks had to get something in the law that would allow investors to buy the pooled mortgages with the same degree of confidence that investors could buy the Fannie and Freddie investments. And this is why in Ibanez you've got all of these steps before the mortgages supposedly got into the trust. Would you like to be Rose Mortgage, the originator? Would you like to be option one, the record title record holder?
Am I the depositor or who am I? The sponsor?
No, you're Lehman Brothers.
Lehman Brothers?
Yes. Yes, sorry. If you would be Lehman Brothers Holdings, which is the seller, and the seller bundles these mortgages together. You,
Oh, my.
Zakia, have the honor of being the Structured Asset Securities Corporation. And Dawn, I'm sorry, but it's worked out that way. You are the U.S. National Bank Association as trustee for the Structured Asset Securities Corporation Mortgage Pass-Through Certificate Series 2006.
Sasco.
Right.
Okay.
So,
Yeah.
so Antonio Ibanez's mortgage he got it from Rose Mortgage, okay? He gave legal title to Rose Mortgage. You're going to need this. Because you're going to pay, when a mortgage is assigned, there's got to be payment. You've got to pay for this. So Rose Mortgage is going to, and
Well, Sarah, I
can we
think,
just imagine that you
Right.
assigned the mortgage, you signed it, you're the grantor, it's the grantee, date, got the notary, you did all that, right?
Yes.
Okay, good.
Or some of it.
No, we're, yeah, right,
Wait, I just paid for this?
yes.
All right, can I see the ratings agency? See what
She's
the-
Michael Lewis.
See what grade I'm buying?
So, U.S. Bank National Association as trustee, it's time for you to foreclose.
Oh, wow.
You're going to foreclose.
Ooh.
Who wants to be the auctioneer?
Alan can be the auctioneer.
Alan, be the auctioneer.
And then is Greg the bank agent?
Are there two Allens? Because I see an Allen down there next to the pig.
Oh,
That's all right.
don't worry about it. Don't worry about it. I assure you, you have the authority to be the auctioneer. So, let's say that the bank has given notices, 3 notices, and published, and it's done everything right about saying it's going to foreclose on Ibanez's home. So would you like to auction off the property?
Yes. We're here to execute on this auction, and do we have any bids? Any bids? Come on.
50,000.
50,000. Very good. Does the bank want to take it back?
Well, let's see, 227,000 owed on it, so
Oh, boy.
we can't take 50, so we'll do the 227,000.
Anybody higher? We'll give it back to the bank.
All right.
Closed.
Who bought?
The bank.
bought it back.
Of course.
Oh, but they
Isn't that a journal entry?
don't pay it.
Yeah, they don't
Yeah.
pay.
Let's
They
have
never.
somebody else buy
He
it, just
would
for the
pay.
sake of clarity.
Okay. Greg would have paid some.
We're going to reopen this.
All right, so Greg paid.
Bought for 280,000.
No, the money goes to them.
No, I get,
Oh.
the bank gets the money, okay?
it actually goes to Harmon and sits there for 6 months. Paperwork's done.
Okay, what did Greg just buy?
A pig and a poke.
How big is it?
You think
No,
so?
just, no, yes.
Right?
The Brooklyn Bridge. Ha.
Greg just bought the Brooklyn Bridge. Why did he buy the Brooklyn Bridge?
Because he thought that the banks don't lie, and if they said they had the mortgage, they must have.
Oh.
Our old friend, Nemo Dot.
Marty still has the shovel.
Right, exactly. Marty still has the shovel. And actually, I should have changed this to Ibanez. Still has his equitable title, right? So,
Unless Marty took it away, Vanya still has his equity sale.
Marty, I'm sure you will good.
What if I went out of business?
There you go.
This is a real problem. But just to be really clear, the bank had nothing to sell. Somebody might have bought, but the bank had nothing to sell. So it was like buying the Brooklyn Bridge. How many Brooklyn Bridge foreclosures would you estimate that Massachusetts has had since about 2005?
There have been a total of 70,000 foreclosures since 2005 in Massachusetts.
So 60,000?
So,
62,000.
Now, this is Brooklyn Bridge. The auctioneer, the bank auctioning it off did not own the mortgage.
almost all.
Almost, probably, yeah.
62,000.
2/3 I've read, I thought.
Well, so the industry says,
The industry said 2/3, right?
the industry said 40,000.
Which is 2/3,
By
right?
industry, do you mean bank or title?
68,000.
The title insurance industry says that of the 70,000, 40,000 were not sold by the party that sold didn't have the mortgage.
You can
We
find
think-
out.
We think it's 60.
Commissioner of Banks has to have it and has to give it up on public request.
That was my mortgage.
Say that
Main option.
Commissioner of Banks
Yeah,
has that information.
I never heard of these other
I don't know
ones.
if they organize it specifically according to the factor, but they have all
Yeah,
proposals.
I'm sure they're not right, but the industry is basing its figures probably on Fannie and Freddie, because Fannie and Freddie have the mortgage, but they don't admit it, and it's not in their name when it's foreclosed. We would argue that it's, the reason that we get, even on this one violation, we get closer to 70,000 is because Fannie and Freddie have 50 to 60%, and we know they don't foreclose in their own name. That's why we went through the Abadi's decision to start with. But then the trusts have another 30%. So this configuration that we just went through, it's about 30%. As folks weren't here, and not everybody was here for the Abadi's conversation, but the Abadi's decision said that there should have been an assignment from Marty to Adam, and from Adam to Lori, and from Lori to Zakiya, and from Zakiya to Dawn, for Dawn to have had the mortgage. And so that 30% is probably in worse trouble in a funny sort of way than Fannie and Freddie.
And did I have any obligation to check any of that out ahead of time?
As the auctioneer, no.
No?
No, you don't. You might have had a responsibility to check it out. I hadn't thought about that, because the other thing that you're going to have done is you're going to have notarized Dawn's agent stepping on the property. And you're going to notarize it as a impartial party to the entry, even though you're getting paid to do the auction and to do the notarization by the same party that's also paying the witnesses half the time and are paying the bank's attorney in fact who was there. So I don't know if you notarized whether you had a responsibility to know that it was the mortgagee that was doing it or not.
Well, why wouldn't
And in one case, the auctioneer is actually a subsidiary of the law firm that does the foreclosure, Orleans Moran.
Well, in terms of Longoria's firm, they generally authorize everybody who was at the auction to be their agent. So we're not sure how the witnesses who witnessed the bank's agent, not yet authorized agent to step on the property, they are also authorized agents of the bank at the auction. So we're not sure how they get to be impartial witnesses, but anyway. It's all, as I said, as I left you with Alice and the Cheshire Cat.
But it would also be nice to know what percentage of people move out of their house after this. How many are still there? How many left?
We don't know that, and we've tried to figure it out.
So the SJC said something very important about the foreclosure auction that Alan just kindly conducted. What did it say about the foreclosure?
It is void.
It's void. What does void mean?
No effect.
Never happened.
They don't have to move. Yeah,
It never happened.
yeah.
Melody.
A nullity. So whereas when Zakiya when Zakia delivered the turf to Brian, something really happened. The ownership changed. When Alan conducted this auction right now, the same thing happened that has happened in at least 40,000 auctions in real life in this state, i.e. nothing happened. But is this of any help to keeping these concepts straight?
Oh, yeah. Yes.
What's important about the void issue is that even after foreclosure, if the homeowner didn't challenge it pre-foreclosure, in an eviction proceeding, if you could get a judge to be honest, you could say, look, you can't evict me because you don't own this property. They say, oh, some of the judge, you should have raised it before. I said, no, I didn't have to raise it before because this whole thing it was rotten from the beginning. It was void from the beginning. So I think that's this whole voidable thing. That's why I think it's really, and obviously we're having a big fight about it.
Well, I have an appeal on that topic, and we're really testing the limits of that void.
Yeah.
Because if it's void, the case I had where it really could have been raised in the beginning, and it was raised as a defense in the summary process case. If it's void, it's void. It shouldn't work. And I think I'd be curious to see if we are successful with that, kind of the limits of that void argument.
Was your case raised in the summary process case, or what?
It was raised as a defense in the summary process
Right.
case, but
That's
this
right.
person had brought a case and lost, challenging the foreclosure before it happened.
Uh-huh.
And this claim, it was a paragraph 22 claim, could have been brought, it absolutely could have been brought in the original case.
Uh-huh.
We raised it as a defense, and we won it, now it's on appeal. But the question is whether or not, can that trump a res judicata issue? Because if it's void, it should have never happened. It should be gone to begin with.
Who was the judge who ruled the right way on it?
Coven.
Mark Coleman.
But I mean, what I think is interesting, because if we really go that far, if it really is void, then a settlement agreement, like a cash for keys agreement, by that implication, should also be void.
Well,
Any sort of effort to fix it
I think that's right.
would be off the record, and it'd be interesting to see really where that goes, if the courts really buy that.
Well, so there's been some success in a different way, which is that the arguments that the pro se documents that we've been evolving make the argument that the summary process court, that their jurisdiction was never activated, because if what you're saying is true and it was void, then the basis of having a court case is there has to be a controversy. But if Brian is still the owner here, and Greg, our Brooklyn Bridge purchaser, attempts to evict him, if Brian's still the owner, then Brian has possession and ownership. There's no controversy for a summary process case to start, because both parties are one party, and there's no controversy to even begin. And there's been 2 appeals court judges on single judge opinions who've agreed that if the foreclosure was void, that there was no standing and there was no basis for.
Can I ask a technical question? What do the cases say about res judicata versus void?
Well, it's an open issue, because the issue being is that it can, on one hand, they're saying that, you have, if it's a paragraph 22 defect, you should be able, you have your one shot to raise it. If you lose, you're out of the game, as we think of it in most cases. But what we're trying to go with, what I'm trying to argue, that if it's void, it really isn't, it's void. It's nothing happened. You can't, I don't even say it's not even so much a defense or a claim as kind of Grace said, it's standing. It's kind of the threshold issue.
Yes, just
And I-
justiciability issue.
And I wish I had raised this kind of analogy. I wish I had done it in my oral argument. But the way I would have said it if I had a chance to do it again would be, it would be the same as if an auction never happened, right? Let's say that the auction never happened in the first place, which is the most extreme example of the foreclosure never happening. Could you really say after the fact, just because I didn't raise that, because I didn't think of raising the sale, does that mean now that I'm forever precluded, even though a foreclosure sale actually never happened? And it's kind of an extreme example, but I think it really goes to that. So we'll kind of see where the courts go on that.
I would encourage you not to see that as an extreme example at all. I I think that that's exactly what
Well,
we're
I guess what I'm
saying.
saying is that, yeah, I mean, there are cases we know of where the sale itself didn't happen. I'm just kind of pushing it to the, make it
It's
as.
a tough case because, and I don't know the details of your case, so more broadly, hypothetically, if you're talking about what's reality, courts don't always reflect reality because they're trying to process cases and there's this idea of finality and, you know, they're not always necessarily getting everything right, but they're resolving a dispute. And so we have a lot of procedural policies so that if a matter is a matter of reality, you do have to raise it and you do have to address it in the court, and if you don't like the results, then the obligation at that point is to take a direct appeal. So if a case happened to terminate or nobody took an appeal at the trial level and the court got it wrong, and then later a party's going to try to use that in a summary process context, then technically under procedure rules you would run into a res judicata issue. However, as Grace pointed out, you might have an interesting side argument where you can't avail yourself of the benefits of that court because it's jurisdictional and you have to have that controversy. And then at the same time, and I don't know if this relates to your case and all that, but just as hypothetically, let's say if in a superior court case, that same case where the judge got it wrong, the other party didn't, the bank, we'll say, didn't raise possession in the superior court. Isn't that waived also? So
I've always wanted to try that.
We haven't gotten anywhere right yet.
well, that's the thing, you can have all kinds of arguments, yeah.
The piece of this that I think is the challenge that this raises, and I hope I'm not stepping on your toes, is that the finality of judgment thing is actually wrong in these cases. Because if the title didn't transfer, it never happened, it was void. The problem exists in the land itself. And that is different than cases, and this is why I think the judges are having such a hard time with the concept of void. There are cases where, and there's some good, interesting SJC decisions, Crowell, and then the underlying decision beneath that, Marley, where in Crowell the court said, if it's a contract claim and you don't bring it, you've missed your opportunity and it's over. But in Marley, I think it's Marley, I'll get the name on our break, the case that underlies it, which they're drawing on when they make the Crowell decision, says, but that wouldn't apply in a case of real property. The reason is because it's not a claim that arises in a court action. Because property has a life of its own, even if there is no court action, what happened to the property happened to the property. And it has its own existence. And I was trying to say to Sarah that I think conceptually the reason we're having a hard time with this is, part of the reason, is because if it has to do with human life, if someone was killed, no one would say, well, it wasn't raised in court. Sorry, finality of judgment. You missed the fact that there's a dead body lying there. Because there's a dead body lying there, it's still a viable issue. It has to get dealt with. Maybe that particular element of it is decided, but there's a dead body to be explained. Real property is only one step away from that. It's not, its existence continues regardless of what happens. And if it's, for instance, on the record, it's visible in the title documents that there was a void transaction, the property is still carrying that legal problem. And so it's not the same as a claim that would arise only in the existence of a court case. Those claims exist in the property themselves. Some of them don't. And so there's a reality check to what happens. And it's one of the things in terms of, I don't know what else is in the case that you're talking about, but the top court has twice said it has to be each element of the foreclosure. So a lot of the cases that we're having raised judicata thrown back at us are ones where one thing or two problems were raised, but there are actually 8 other ones. And if each of those separately render the foreclosure void, it's not the court deciding that it's void, it's what happened. It's the dead body deciding what happened. The court can't say, well, we decided that the body isn't really dead and we have finality of judgment over it. It doesn't work.
So you're saying the theory is it's almost like a continuing violation, is that what you're saying?
Yes, and I think it's a multiple violation. Sarah, we keep trying to find the right language for this, and Sarah, as a prosecutor, was saying she thinks of it as elements of a proof. Whereas if you don't have all the elements, then you don't get from here to there. And I'm not comfortable with that analogy exactly, because what we know is, so say that you went to court and you argued that the notice, you never got your notice of sale, and they didn't do a public proclamation to postpone, and so there should have been another notice in the paper. And the court says, not a problem, sorry. But if it turns out that Dawn didn't have the mortgage and she tried to auction it, that problem still exists in the title to the property.
Well,
She
that's
didn't
avoid-
have an ability to
That's the
auction
void,
it.
Stephen, that's the void issue, not the whether you pled all the, that's the
Well, but
void.
that's what I'm saying is the
That's
void,
the void issue, it's not just,
right, the voidness trumps whether you pled it or not.
that's right.
But that's what we need to, that's what we're waiting to figure out.
That's a hard thing to
And the
argue
SGC has already-
hypothetically. I mean, you need specific facts because, I'm trying to make sense of this. There is precedent maybe you can come up with a constitutional issue there, but there is precedent where a court will decide something with finality, and then later on when the judgment is trying to be enforced in another time and then it ends up back in court, you can say, well, that prior court ruling is void. The ruling itself is void because it didn't meet constitutional muster.
Right.
If you're talking about
That's
a
exactly
ruling
what
of
we're talking
fact, the problem is that technically you can simply bind the parties and unless you go back to that same court and ask
Exactly.
for a rehearing or
That's
appeal it.
exactly right, and you just named what the problem
It's a
is,
real
which is
issue.
that you're
It's real
binding
issue.
the parties
What's
that are
that?
in front of you. But title is not determined by the parties in front of you.
Well, that's
Title
a-
is determined by anybody who
Right.
has a viable claim.
Well, that's a-
So if I'm a judge and I bind, you're the post-foreclosure purchaser, except it wasn't a foreclosure, and Sarah is the post-foreclosure homeowner that you're evicting. And as a judge, I bind the two of you by my decision that the foreclosure was void. It was not void. The problem is, I'm not doing a title claim. To do a title claim, I need Dawn and Zakiya and Lori and Adam and Marty and Nadine, because they all might have a claim to this title. And so the reason that title theory, the titles work differently, it was, so let me tell a brief story, I apologize, but we met with the chief judges of Superior Court, Land Court, and two trial judges. And there was no one there for housing court because at the time there was no, they were
Since
in
last week.
transition. They had shifted over to the new head of the housing court. And we talked to them for quite a while, and then we were outside in the hallway, we had run out of time. And I mentioned, they were saying, look, they're going to be, you're saying they're going to be 40, 60,000 cases, there really should be some way to speed this up. And I said, well, we've talked about doing multi-party suits where there's a shared problem, like we're all FHA written mortgages and they were all violated by the same bank. So we're going to go after JP Morgan Chase, let's say, on all these FHA written mortgages and sort out the title issue. And the Superior Court Chief Judge said, oh, that's great. We could do a whole bunch of them at once. And the Chief Land Court Judge almost had apoplexy. Because she's used to sorting out title, and what was in her head was, I have 20 titles to clear, and it's not going to be just JP Morgan Chase and the 20 homeowners. It's going to be JP Morgan Chase, the 20 homeowners, and the other multiple of 20 different parties that might have a claim. And that's because the only way to clear title is by having notification to anybody who has a right to that title, potentially. And so housing court literally can't have jurisdiction over clearing title. So if they're doing anything, all they could be doing would be saying there's no controversy over the title. Because if there's a controversy, they no longer have jurisdiction. Controversy over title has to be in land court or superior court. And I don't think that's been sorted out by the courts, but what's absolutely clear to me is that most of the judges who think they're determining title don't understand that there's only one way to clear a title, if we're still in real property law land, which I'm not sure we are, but if we are.
Here's the case that I think it's easier. I think don't you just look at the elements either issue, some kind of issue preclusion. In other words, and one of the key elements has to be that there's an identity of parties and an identity of issues, right? In Massachusetts, it's the minority rule, it has to be privity between the parties. And so if the lenders try to say, oh, well, all of you Lehman Brothers and everybody else, of course there's privity. Well, first of all, if it starts out, because there's no judicial foreclosure, if it starts out as a summary process case, they won't approve it in the summary. They won't approve it in the summary case, and obviously there's no, they don't have the, because they fucked up the paper, there's no way that they could show, the assignments are lacking. So therefore, you have a right to raise superior right to possession in the summary process case, or if there was no superior court case and there's no judicial foreclosure, well, there has to be something. Is your case still
Lee, you're absolutely right, and the place we're running into problems with the decisions that we're seeing from the appeals court is that they're treating it as claim preclusion instead of issue preclusion, and none of these are claim preclusion, they're issue preclusion.
Well,
And so
the courts are really confused. I mean,
they're
I just did a case.
completely at a loss.
You have to, when you do that, you have to really walk them through that, like it's
That's
going
right.
back to
You have to
law.
walk them through. the
Yeah, you
process.
have to really, go through that
That's,
very
but
carefully.
that's the argument that we think is, but Lee, you're on the argument that we think is the right
Well,
one.
that's right. You don't do this like sort of continuing violations about land that you didn't raise.
It's
Well,
tricky,
that's not-
yeah.
That's the wrong argument. That's not gonna-
That's scary.
gonna win. But if you look at the technical requirements of issue preclusion, claim preclusion, issue preclusion, and the courts are really confusing about, they call one the other.
Well, if
think
I
that
understand you correctly, in all of you kind of seems like in the hypothetical we're discussing, you're talking about the parties that aren't bound are part of the banking industry, this tree of
That's right.
banks. And so the problem is, it can create a bizarre anomaly if a court gets something really wrong, but where will that problem, where will the conflict actually arise? Because these guys are all in bed together, they're not gonna care. Behind the scenes,
Actually,
they'll fix
that's not
everything.
true. There's
So
still-
if I'm, well, sometimes they do, yeah, so that we need that case though, is what I'm saying, that the hypotheticals are tough. So if you're talking about binding the mortgagor, the mortgagor is binding his heirs, assigns, so they're out of it now. Even if the court gets
But they're
wrong.
not out of it, because this is the thing about real property law. They're not out of it because it was void. It's the thing that Adam was talking about and that I was saying about jurisdiction. The problem here is that the courts are trying to determine things they don't have the authority to determine. And what the SJC said twice, in Eden and in, I'll have to go look it up again, is that each of these violations of the foreclosure individually void the foreclosure. It's not, foreclosure is not a claim in the sense of being an invalid foreclosure is not a claim in the sense that it's a single argument.
I'm with you on
It's a series
that,
of
but at
issues.
some point, if there's a challenge, the court has to recognize it. In all the cases you cited, they went linearly. They went into court, they were dissatisfied, they
Right.
appealed it, and they appealed. And that's actually the paradigm that we're, so, if you're saying this is another argument, or my idea about constitutionalness, we have to have specific facts, because it just gets.
Well, so, but this is the argument.
Because the issue, I mean, there are two levels. I think this is level.
Yeah.
So you have to have justiciability before you can get to the substantive issue of avoidance,
Thank you.
right? Excuse me if I'm talking too technically, but you have to have justiciability before talking the issue of technicals. What the courts have tried to do is knock out essentially the standing argument by saying that, oh, there's been some kind of issue preclusion. So it seems to be step number one.
Yeah.
Step number one is first to say, well, if there was some kind of prior court case, no, it's justiciable because you can hear it. You can hear the case because they didn't comport with the elements of.
They didn't have a day in court, or the issue wasn't
That's right,
decided.
and all these intermediate.
That's constitutional.
And all these intermediate parties weren't even parties to the other scene, and they're not in privity because they don't. So then that's step one, and then once you get past step one,